of sequestration. What we're really talking about is innovation here. And innovation generally doesn't happen in the big companies. It happens in the small companies, the companies that are able to move quickly so that we get what we need. And that's what the RIF program is about. This is not an earmark. In fact, just yesterday, the pre-notification for the fiscal year 13 process was released. It said any and all companies can put forward proposals. That's not an earmark. The RIF process contributes to cost savings to the service's training activities. In fact, the Navy added cost reduction as a critical focus area in the fiscal year 12 Rapid Innovation Fund broad agency announcement. And several of these selected RIF projects actually seek to reduce operations and maintenance costs to include the cost of training. I urge a no vote on this amendment.
Gentlewoman's time has expired. Gentleman from Washington reserves. Gentleman from Colorado is recognized. Gentleman from Colorado has 30 seconds remaining.
Mr. Speaker, there are already 76, in this bill, there's already $76 million for quick reaction and special projects, $62 million for emerging capabilities technology development, $174 million for joint capability technology demonstrations, and $34 million for the Defense-wide Manufacturing Science and Technology program. The Department of Defense Small Business Innovation Research and Small Business Technology Transfer programs spend about $1 billion per year in research and development funding for our nation's small technology companies. So the issues that they're talking about are already addressed in multiple ways, and this is really this is unfortunately wasteful Pentagon spending that's got to be cut.
The gentleman from Washington is recognized.
Thank you, Mr. Chairman. Could I request how much time I have left?
Gentleman from Washington has a minute and a half remaining.
Thank you. I yield a minute to the gentleman from Rhode Island, Mr. Langevin.
Gentleman from Rhode Island is recognized for 1 minute. Without objection, so ordered.
I thank the gentleman for yielding. While I fully understand and appreciate the gentleman from Colorado's intention, I must strongly disagree with his amendment, specifically its choice of offset. Cutting our future to pay for the present is the very definition of penny wise and pound foolish. This amendment would have a severe negative impact on small businesses in the defense industry. The Rapid Innovation Fund was created by the Armed Services Committee. It is a fully competitive program to facilitate the rapid insertion of innovative small business technologies and processes into military systems or programs that meet critical national security needs of the warfighter. Projects are underway now, and just yesterday the pre-notification for the FY13 process was released. The Rapid Innovation Fund process contributes to the cost savings of the service's training activities. In fact, the Navy added cost reduction as a critical focus area in its FY12 Rapid Innovation Fund broad agency announcement. So several of the selected RAF projects actually seek to reduce O&M costs to include the cost of training. So according to the Department, RIF, and I quote, has a high return on investment while providing a venue for the timely, innovative solutions from small businesses to our near-term challenges. I yield back.
Gentleman yields back. Gentleman from Washington is recognized for 30 seconds.
Thank you, Mr. Speaker. In conclusion, I'd ask my colleagues to vote no on this amendment. I think we've made a good case. I think folks have heard the argument. Just a final note. This defense business panel that Mr. Schuster's Pennsylvania spoke of, we did travel around the country, talking to small businesses all over the country in many states. And everywhere we heard that this is the program. The Rapid Innovation Fund is the program that they see as most valuable. They want us to keep this in place. So I would ask my colleagues to vote no on this amendment. And with that, I yield back.
Gentleman's time has expired. The question is on the amendment offered by the gentleman from Colorado. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. For what purposes the gentleman from Colorado seek recognition?
I'd ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Colorado will be postponed. For what purpose does the gentleman from California seek recognition?
Mr. Chairman, pursuant to HRES 260, I offer amendments en bloc.
The clerk will designate the amendments en bloc.
En bloc number 1, consisting of amendments numbered 7, 8, 16, 17, 24, 26, 30, 34, 35, 40, 41, 42, 48, 62, 94, 111, 113, 130, 154, and 159, printed in House Report number 113-108, offered by Mr. McKeon of California.
Pursuant to House Resolution 260, the gentleman from California, Mr. McKeon, and the gentleman from Washington, Mr. Smith, each will control 10 minutes. The chair recognizes the gentleman from California. Mr. McKeon.
Mr. Chairman, I urge the committee to adopt the amendments en bloc, all of which have been examined by both the majority and the minority. Mr. Chair, at this time I yield 1 minute to my friend and colleague, the gentleman from Florida, Mr. Bilirakis.
Gentleman from Florida is recognized for 1 minute.
Thank you, Mr. Chairman. I appreciate it very much. Mr. Speaker, I rise today in support of my amendment which would allow disabled veterans with a service-connected permanent disability rated as total to travel on military aircraft on a space-available basis. My amendment would allow disabled veterans who have bravely served our country and have made enormous personal sacrifices that follow them in their daily lives to travel through the Space A program at no additional cost to the Department of Defense. The Space Available program is a DoD program which allows active duty service members, their families, retirees, and certain others to fill empty seats on DoD flights. While active duty members and their families will remain the primary beneficiaries of this program, in order to assist them with the rigors of military life, my amendment allows these veterans the same benefit. I would like to thank Chairman McKeon and Ranking Member Smith and their staffs for their assistance in the amendment process. And I yield back. Thank you, Mr. Speaker.
Gentleman from Florida's time has expired. The gentleman from California reserves. The gentleman from Washington is recognized.
Thank you, Mr. Chairman. I yield 3 minutes to the gentlelady from Illinois, Ms. Duckworth.
Gentlewoman from Illinois is recognized for 3 minutes.
Mr. Speaker, I rise in support of my amendment which will strengthen small business participation in government contracts. In my district and across the country, small businesses are the backbone of our economy. Small businesses innovate, know how to operate on a tight budget, and create good-paying jobs. I want small businesses in places like Elgin, Illinois, to be able to win government contracts from the Department of Defense because I know they will do more with taxpayer dollars and provide superior products and services for our men and women in uniform. However, the government is lagging behind on awarding contracts to small businesses. We're not meeting our goals of 23% of contracts going to small businesses. 23% is a pretty low bar that we should be raising even higher, not be struggling to meet. It is even more unfortunate that we are also failing to award enough contracts to women and veteran-owned small businesses. My amendment seeks to remedy this problem by asking the Small Business Administration and federal agencies to include remediation plans in their annual report on small business contracting goals. The government should explain why it's not meeting its small business goals. It should identify faulty past practices and propose new businesses and practices to increase small business participation. We need an action plan to support our small businesses, and my amendment will do just that. I thank Chairman McKeon and Ranking Member Smith and the committee staff for their help on this amendment, and I urge my colleagues to support this amendment and our small businesses. Thank you, and I yield back the remainder of my time.
Gentlewoman from Illinois yields back. The gentleman from Washington reserves. Gentleman from California is recognized.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentleman from Pennsylvania, Mr. Fitzpatrick.
Gentleman from Pennsylvania is recognized for 1 minute.
Thank the Chairman for the opportunity to address 2 amendments which are part of this package. The first is my amendment to protect military tuition assistance, an important tool for members of armed services to obtain the necessary professional development education and prepare themselves for the civilian job market upon leaving the service. Last year, approximately 300,000 service members used tuition assistance to pursue their educational goals. Unfortunately, last March, the administration chose to end this program, and it took congressional action to overturn that decision. This amendment would prevent even the specter of ending this benefit from ever happening again. Our soldiers, sailors, airmen, and Marines deserve better. Second included in this package is an amendment requiring the Secretary of Defense to conduct a study on veteran-owned small business contracting and examine the feasibility of putting a priority on meeting veteran-owned small business contracting goals first, similar to a successful program in the VA. They'll be examining how fair contracting practices for veteran-owned small businesses could positively affect veteran unemployment, homelessness, and even suicide. Mr. Chairman, the fact is there are 250,000 service members transitioning each year from military life to civilian life. 1 in 7 are self-employed or small business owners, and about a quarter of our veterans say they're interested in starting or buying their own small businesses. They play an important role in our economy. This Congress needs to help them in the transition and getting America back to work. So I'd like to thank the Chairman and Ranking Member on the bill and urge the support of these amendments. I yield back.
The gentleman's time has expired. The gentleman from California reserves. The gentleman from Washington is recognized.
Thank you, Mr. Speaker. I yield 2 minutes to the gentlelady from Florida, Ms. Frankel.
The gentlelady from Florida is recognized for 2 minutes.
Thank you, Mr. Chairman. I'm the mother of a United States Marine War veteran, and I remember well the pride my son felt when he put on his uniform. My constituent, Alicia Morrow, felt the same pride when at age 22 she joined the United States Coast Guard. She started boot camp full of hope for her future, and that hope quickly turned into humiliation and sorrow as her company commander became her enemy. First he ordered her to clean his office, and later harassed her with sexual innuendos and advancements night after night. Feeling hopeless and fearing retribution, Alicia stayed silent until the commander became more emboldened. He again ordered another female recruit to his office at night. This time, he ordered her to remove her clothes and engage in unwanted sex. Thankfully, the victimized servicewoman was brave enough to pursue charges, but because it was determined that she was not under physical threat and she did not fear for her life, her assailant got away with a lesser offense of cruelty and maltreatment and adultery instead of being charged with rape. And this is not full justice. When our daughters and our sons put on the uniform to protect us, the United States, they must be protected from such abuse of power to the utmost extent. And, Mr. Chair, the intention of this amendment is to do just that. I thank you, and I yield back my time.
Gentlewoman from Florida yields back. The gentleman from Washington reserves the balance of his time, and the gentleman from California is recognized.
Mr. Chairman, I yield 1 minute to my friend and colleague, the gentleman from Kansas, Mr. Hulskamp.
The gentleman from Kansas is recognized for 1 minute.
Thank you, Mr. Speaker, and I want to thank the Chairman for yielding to me. I appreciate especially his effort on the NDA last year, in which we were able to add language that would require the Department of Defense to adopt new regulations to protect the religious liberties of our military personnel, especially our brave chaplains. However, since March and since the adoption of that law, we have sent 3 letters to the Department of Defense asking for progress updates, and the Department has only responded with an acknowledgement that it has received our letters, but to date we are unaware of any progress. Instead, it seems that secretive meetings continue with individuals actually opposed to religious liberties. In light of this delay, my amendment is very simple. It would require the Department to provide Congress with a report on meetings between employees and civilians with respect to the development of military policy related to religious liberty. And I encourage my colleagues to support this amendment, and I yield back.
Gentleman from Kansas yields back. A gentleman from California reserves. Gentleman from Washington is recognized.
Thank you, Mr. Speaker. I yield 1 minute to the gentleman from Texas, Mr. Cuellar.
Gentleman from Texas is recognized for 1 minute.
Thank you. Mr. Speaker, I rise today to encourage my colleagues to support my amendment to the National Defense Authorization Act. This amendment will bring the Department of Defense and other federal, state, and local agencies together to map out the futures of UAV. I first want to thank the Chairman McKeon and the Ranking Member Smith and their staff for their assistance on this important issue. I also want to thank those who have co-sponsored this amendment, Representative Gene Green, Representative Ted Poe, and Chairman Michael McCall. This amendment calls for the Secretary of Defense in consultation with the Department of Homeland Security and the Federal Aviation Administration to develop and implement plans to review the potential of joint testing training that might serve the dual purpose of providing capabilities to the Department of Defense to protect us abroad and on the international border. This amendment will go a long way to make sure we utilize all available resources and not waste taxpayers' money. I urge all my colleagues to vote yes on this amendment, and I yield back the balance of my time, Mr. Speaker.
The gentleman from Texas yields back. The gentleman from Washington reserves. The gentleman from California is recognized.
Mr. Chairman, I yield 1 minute. My friend and colleague, the gentleman from Oklahoma, Mr. Bridenstine.
The gentleman from Oklahoma is recognized for 1 minute.
Thank you, Mr. Speaker. I'd like to thank my friend from Kansas, Mr. Hulskamp, for offering amendment number 236. He is a champion for religious freedom. As a Navy pilot with Iraq and Afghanistan combat tours, I am concerned that senior Air Force officials have taken advice from an anti-Christian zealot when drafting guidance on culture and standards. The president of the badly misnamed Military Religious Freedom Foundation, Mr. Mickey Weinstein, has described Christians as human monsters and monstrously savage, responsible for racism, bigotry, and prejudice. He even called the presence of committed Christians in the military a national security threat, comparable to al-Qaeda. Mr. Speaker, we're not asking to approve the military's calendar appointments, but given this situation, Congress needs to know when the military meets with anti-Christian fanatics on issues regarding religious liberty. I urge my colleagues to support this amendment, and I yield back.
The gentleman from Oklahoma yields back. The gentleman from California reserves. The gentleman from Washington is recognized.
I reserve my time at this time.
The gentleman from Washington reserves. The gentleman from California is recognized.
Mr. Chairman, we have no further speakers.
Gentleman.
Thank you. I have no further speakers either. I yield back the balance of the time.
Gentleman from Washington yields back the balance of his time. Gentleman from California is recognized.
I encourage our colleagues to support the en bloc amendment. Yield back the balance of my time.
Gentleman from California yields back the balance of his time. The question is on the amendments en bloc offered by the gentleman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The en bloc amendments are agreed to. It's now in order to consider amendment number 6, printed in Part B of House Report 113-108. For what purpose does the gentleman from Ohio seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 6, printed in Part B of House Report number 113-108, offered by Mr. Turner of Ohio.
Pursuant to House Resolution 260, the gentleman from Ohio, Mr. Turner, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Ohio.
Thank you, Mr. Chairman. Mr. Chairman, I want to thank Chairman McKeon, Ranking Member Adam Smith, for their efforts. They had given to Representative Zongas and myself the task of doing a bipartisan package to address the issue of sexual assault in the military. We all know, and people have spoken on this House floor eloquently, of the tragedy of the issue of sexual assault in the military. We have to do something both to change the culture and to change the legislative regime that affects the prosecution and the prevention of sexual assault and the protection of victims. Many times victims report that they are re-victimized by the system. It is our effort in changing the system so that the perpetrator fears the system, not the victim. But there is one other thing that we need to address. Mr. Chairman, many people have taken this House floor and say we need to go farther. Well, the Turner Amendment is what we need to do to go farther. We have put in this bill currently a mandatory minimum, meaning that if you commit a sexual assault, you are subject to a statutory minimum. That minimum in this bill, unfortunately, is only you're out of the military. We want to increase that to include 2 years of confinement. Mr. Chairman, 22 states have mandatory minimums that include confinement, incarceration. Of those 22 states, we took the minimum of those so that we're not going higher than any state. But here's the issue, Mr. Chairman, that we need to remedy. Unfortunately, under current law, if you commit a sexual assault on a base that's in a state that has a mandatory minimum, you might actually avoid a mandatory minimum, and that has happened. In the case of Marine Corps Gunnery Sergeant Nicholas Howard, he committed a rape on a 23-year-old woman. He was a recruiter in Alaska. He was convicted of sexual assault due to DNA testing, and he was found guilty of first-degree sexual assault. He was given a dishonorable discharge, but no jail time. In Alaska, he would have been subject to incarceration. Mr. Chairman, we should not have people who are in uniform or on base committing sexual assaults actually avoid jail time because they're in the military. We shouldn't have a lower standard. With that, Mr. Chairman, I would like to yield a minute and a half to Ms. Leworski.
Gentlewoman from Indiana is recognized for a minute and a half.
Thank you, Mr. Chairman. I'd like to thank Representative Turner for giving me this opportunity to speak in favor of his amendment. He's been a leader on this issue, and I applaud his efforts and a commitment to this cause. Currently, there's no minimum punishment required when somebody is convicted of military sexual assault. This means a service member can be convicted of a serious crime and receive no punishment. The amendment will impose a mandatory minimum sentence of 2 years confinement and a dishonorable discharge for conviction of rape and sexual assault. Right now, 22 states have mandatory minimum sentences for those convicted of rape and sexual assault. My state, Indiana, is one of those states. In Indiana, there's a mandatory sentence of not less than 6 years for rape. It's inexcusable that service members guilty of the most heinous crime should be allowed to remain in the military, allowing them to coexist with victims and potentially commit repeated offenses. Criminals must receive the full weight of justice for their wrongdoing. American sons and daughters deserve protection while serving in the military and should never feel vulnerable or re-victimized after suffering from any form of sexual assault or misconduct. This amendment is a much-needed reform that ensures victims receive the justice they deserve. Thank you, and I yield back my time.
Gentlewoman from Indiana
reserve the balance of her time.
Gentleman from Ohio reserves the balance of his time. For what purpose does the gentlewoman from California seek recognition?
Thank you, Mr. Speaker. I yield the time for opposition.
A gentlewoman is recognized for 5 minutes.
Reserve the time for opposition. Mr. Speaker, I really respect the gentleman and what he's bringing forward, but the reality is that mandatory minimums have been shown to actually reduce the incidence of reporting. Judges and juries need the ability to decide with discretion and not strictly by its appearance. Sometimes, and we've seen this many times, mandatory minimums can have the opposite effect, encouraging jurors to make a decision based on the potential sentence as opposed to the facts. And that's why I'm standing in opposition, because we also know that organizations who have worked very hard to look at this issue worry that this could go in the wrong direction. Protect Our Defenders, which has been a very, very strong advocacy group for victims, worries that when a jury knows that a perpetrator will automatically be dishonorably discharged, that the jury will be less likely to assign confinement charges in addition. They need to see the full picture. So we must take caution to judge every case individually. I reserve the balance of my time. We have some additional speakers.
Gentlewoman from California reserves the balance of her time. The gentleman from Ohio is recognized.
I reserve.
Gentleman from Ohio reserves his time. Gentlewoman from California is recognized.
I'm pleased to yield 3 minutes to the gentlewoman from Massachusetts.
Gentlewoman from Massachusetts is recognized for 3 minutes.
Thank you, Mr. Speaker. I value my partnership with Congressman Turner as co-chairs of the Military Sexual Assault Prevention Caucus and with the legislation we have crafted on combating the horrific crime of sexual assault in the military. This year, our work together on the Better Enforcement for Sexual Assault-Free Environment Act, otherwise known as Be Safe, led to its incorporation into the NDAA before us today. However, I must take exception to the amendment before us. I do agree that we must make sure that all individuals who are convicted of sexual assault in the military are punished with confinement. Absolutely. But there are many different ideas about the best way to do that. Some argue that a better approach would be a system similar to federal sentencing guidelines. And that's why Mr. Turner and I wrote a provision in the defense authorization before us that requires the Secretary of Defense to provide Congress with a report on sentencing guidelines and mandatory minimum sentencing provisions under the UCMJ. Before we make additional changes to the UCMJ, we need to see this report. Since we have introduced the Be Safe Act, we have heard from many groups. One letter from the National Alliance to End Sexual Violence says, quote, long mandatory minimum sentences can have a chilling effect on reporting and prosecuting sexual assault in the civilian system, and the National Association to End Sexual Violence does not recommend them. We have to listen to these various voices. We cannot afford to take this risk in the military. Reporting of sexual assault in the military already happens at abysmal rates. We need more reporting, not less. Less reporting equals fewer prosecutions, which ultimately will fail to deter the perpetrators from carrying out this heinous crime. I urge a no vote on this amendment. Thank you, and I yield back.
Gentlewoman yields back. The gentlewoman from California reserves. The gentleman from Ohio is recognized.
Mr. Chairman, how much time do I have remaining?
Gentleman from Ohio has 2 minutes remaining.
Do I have the right to close, Mr. Chairman?
Gentlelady from California will have the right to close.
Okay. Mr. Chairman, I appreciate the concern that I've heard from the other side of the aisle. The issue, I think, comes down to that being in a military uniform should not be a get-out-of-the-jail-free card. Basically, the state of the law is that if you're in a state that has a mandatory minimum and you commit a sexual assault or a rape, you're going to jail. But yet, under our law, you could be a member of the military and commit a sexual assault or rape and be free from incarceration, even if you commit the assault or the rape off base. When we talk about wanting to make certain that we uphold the victims and making certain that it's the perpetrator that is the person that feels insecure and threatened by the system, you can't have a system that threatens a perpetrator when the perpetrator knows that by being a man or woman in uniform or by being on base and a member of the military, that you're subject to a lower standard in conviction and sentencing. The case that we have in Alaska where a member of our military, a member of the Marine Corps, committed a rape and then received no jail time whatsoever. No jail time whatsoever. And if he had been off base or if he'd been a civilian in Alaska, would have been subject to a significant mandatory minimum of incarceration. When people ask what's different in the military, this is different. We need a mandatory minimum that says if you commit a sexual assault and you're convicted, you are out of the military, you are dishonorable discharged, and you are going to jail. And that mandatory minimum will be at least 2 years of incarceration. I was just at a facility where I asked the commanders what had occurred on their facility with sexual assault, and they reported that there had been a sexual assault and there was currently someone in jail in the brig for 7 months. They didn't get a dishonorable discharge. That's all they got, 7 months. They were going to be out walking among their fellow men and women in uniform, and they will have committed a sexual assault. That has a chilling effect both on reporting, and it also has it gives an environment where people who are perpetrators feel that they could be safe. Our law, this amendment, would make it you're out, mandatory, dishonorable discharge, 2 years in prison, and that's it. We urge support for the Turner Amendment. Thank you.
Gentleman from Ohio's time has expired. The gentlewoman from California is recognized.
Thank you. I yield 2 minutes to the gentlelady from California. How much time do I have remaining?
Gentlewoman has a minute and a half remaining.
Minute and a half. I yield a minute.
Thank you
to lady is recognized for 1 minute.
Thank you, Mr. Chairman, and thank you to the ranking member. And I rise in opposition to this amendment. Congress is, of course, outraged over the ongoing cases of sexual assault and sexual harassment occurring in our military. There's no one in this chamber who doesn't believe that criminals should pay for such violent and atrocious crimes. And so I understand why my good colleague on the other side would offer such an amendment. I'll say several things. First, I'm pretty much opposed to mandatory minimum sentences in general. But this base bill, the base bill that we're considering today, the committee requires the Department of Defense to provide a report on mandatory minimums and sentencing guidelines in order to make sure that such sentencing reforms will not discourage the victims from reporting. And in addition to that, in the base bill, if you are convicted of these crimes, you will be dishonorably discharged. So in order to avoid imposing laws that may harm victims, I urge my colleagues to vote against this amendment, and I yield back the balance of my time.
Gentlewoman yields back. The gentlewoman from California is recognized. Gentlewoman from California is recognized for 30 seconds.
Okay. Thank you, Mr. Speaker. This is a complex issue. We know that. And I think what we feel is that this further complicates it. I think my colleague has introduced with Congresswoman Tsongas a bill that does much of what we're talking about here, but there is an exception in terms of the way that the jury is able to move forward here. And we think that this actually makes sense so that the decisions that are made are absolutely based on an individual case and what we can offer in terms of making certain that the perpetrator is held accountable. I yield back my time.
The question is on the amendment offered by the gentleman from Ohio. Will those in favor say aye? Aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider Amendment Number 9, printed in Part B of House Report 113-108. For what purpose does the gentleman from Virginia seek recognition?
I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 9, printed in Part B of House Report number 113-108, offered by Mr. Ridgell of Virginia.
Pursuant to House Resolution 260, the gentleman from Virginia, Mr. Ridgell, and a member opposed each will control 5 minutes. The chair recognizes the gentleman from Virginia.
I thank the chairman. Mr. Chairman, these are very, very challenging fiscal times. Our deficit continues to grow, and that's putting pressure on every single line of our federal budget, including defense, and yet the world has not become a safer place. So what's clear, Mr. Speaker, is that we have a duty, an absolute duty, to invest each and every dollar of our defense dollars wisely, and that's exactly what my amendment does. It does that by eliminating a regulation that's holding back competition, and in doing so, it's hurting the American taxpayer. When it comes to understanding the value of introducing competition into things, the American people get it. From groceries to computers, we know that when competition is introduced, that good things happen. The prices go down and the quality goes up. Now, the same is true, or it should be true, when it comes to the Department of Defense and the ability of the private sector and the public sector to compete. Now, President Obama put it this way. He said, taxpayers may receive more value for their dollars if non-inherently governmental activities that can be provided commercially are subject to the forces of competition. You know, in my service to my district, I'm always looking for common sense ideas and common ground. And on this particular issue, I see both in the President's statement. My amendment moves competition forward by eliminating a full moratorium that Congress has put in place. And it said, the Department of Defense said in 2011 that it wanted that particular moratorium removed so it could meet its statutory obligation. Now, what is that statutory obligation? It's this. This comes right out of their own report and recommendations. The Secretary of Defense shall use the least costly form of personnel consistent with military requirements and other needs of the department. Well, we know that some activities are inherently governmental. For example, criminal investigations. My amendment has nothing to do with those type of activities. They should be performed by the federal government. But other activities, Mr. Chairman, for example, janitorial services, that's not inherently governmental and should be subject to competition, and that's what this amendment opens up. It really isn't affecting what's known as the 50-50 rule and those core services that are provided by depots. So I believe that the amendment represents both common sense and common ground. I urge my colleagues to vote for it, and I'd like to yield a minute to my friend, Mr. Kaufman.
The gentleman from Colorado is recognized for 1 minute.
Mr. Chairman, over the past few years, the prevailing trend within the Department of Defense has been an over-reliance on federal employees to perform commercial services. Given our nation's need for fiscal austerity, a problem made more acute by mandated sequester cuts, it is important that Congress provide the Pentagon with the necessary tools to drive efficiencies and cost savings. Public-private competitions are one such tool. Public-private competitions are an effective way of injecting performance and accountability into government operations. The private sector constantly competes for new business opportunities. When the federal government performs commercial functions, they too should be required to compete. Unfortunately, Congress has placed a moratorium on public-private cost competitions, effectively granting monopoly power to the federal government when it comes to providing commercially available goods and services. We all know that without competition, both innovation and quality suffer. The amendment does not mandate the use of public-private competitions. It simply unlocks an essential tool that the Defense Department can use to drive cost-effectiveness and efficiencies and save valuable taxpayer dollars.
Time has expired. The gentleman from Virginia reserves.
I reserve the balance of my time.
Reserves. For what purpose does the gentlewoman from Hawaii seek recognition?
Mr. Speaker, I claim the time in opposition to the Regal Amendment.
The gentlewoman from Hawaii is recognized for 5 minutes.
Mr. Speaker, I yield myself 1 minute.
Gentlewoman is recognized for 1 minute.
Mr. Speaker, the Regal Amendment would lift the current moratorium on the public-private competition to the A-76 process. Unfortunately, is based on very faulty assumptions. Lifting the moratorium will eliminate the incentives the Department needs to fix the A-76 process as well as finish the service contracts inventory. It's based on the following assumptions which have been proven to be faulty. One, that the private contractors for some reason save money, and we know from the POGO reports that that is not true. As DoD evaluates the correct balance between civilian and contractor personnel, it is critical to make sure that our federal employees, the strength of our country, the backbone of defense, are protected. Efficient government requires focused attention on supporting and strengthening our dedicated federal workforce and making sure that they have the tools to complete our mission. And I reserve the balance of my time.
Gentlelady reserved. Gentleman from Virginia.
I just would respond to the gentlelady. I appreciate her comments, and I too am a strong supporter of our federal workforce. I just believe that they can compete and should compete. This is good for America, good for our ability to defend our great country, and good for the American taxpayer. I reserve the balance of my time.
Gentleman reserves the balance of his time.
Mr. Chairman, I yield 1 minute to Mr. Cartwright of Pennsylvania.
Gentleman's recognized for 1 minute.
Thank you, Mr. Speaker and Representative Hanabusa. Mr. Chairman, I rise in opposition to this amendment and in support of the over 5,000 men and women who work at the Toby Hanna Army Depot who support our warfighters. The OMB Circular A-76 process, which this amendment seeks to reinstate, has been prohibited because it's unfair to federal employees and wasteful of taxpayer dollars. The OMB and the Pentagon, who have historically been the biggest boosters of this process, both acknowledge that A-76 is flawed and they oppose its revival. The DoD acknowledges it's still improving its statutorily required improvements, and it would be rash for us to jump past their internal procedures for improvement. Lifting the moratorium would eliminate the incentives the Department needs to fix the A-76 process, and we would not be doing our jobs if we rushed to allow a flawed procedure to lay off our dedicated civilian workforce and, in many cases, hurt the taxpayers in the process. And I yield back.
Gentleman from Virginia.
I just refuse to agree with the gentleman's proposition there about laying federal employees off. This does not state that it has nothing to do with that. In fact, it just simply says that this is a tool for the Department of Defense to use. It does not require public-private competitions to go forward. I just believe in the federal worker. I believe in the free market as well, that competition is a good thing. And it needs to be introduced because this is how we will make our defense dollars go as far as they can possibly go. I see this as a duty to the American people to advance this amendment. I ask my colleagues to support it. I yield back.
Gentleman yields back the balance of his time. Gentlelady from Hawaii.
Mr. Chairman, I yield 1 minute to Mr. Bishop of Utah.
Gentleman from Utah is recognized for 1 minute.
Thank you, Mr. Chairman. Even though I appreciate the efforts and the goals of the gentlemen who are introducing this amendment, the experience at most of our air logistics centers simply means that A-76 has brought along delays, and those delays, even if they're in the form of a study, have caused the work to delay, meaning the product given to the warfighter is delayed, and the fixed cost overhead that our depots obviously face have to be paid from some source, which is indeed the taxpayer. A-76 is about low cost, not necessarily best value, which means if you're dealing with a market system where something goes out there, you see if it sells or not, that's okay. But you are dealing with military equipment which must be performed and must be repaired on a timely basis and in a specific way. And that is why the Department of Defense, the Office of Management and Budget are both opposing this amendment, as well as why they halted the process in the first place, because they found there are structural flaws inherent in this process. It is better to go about finding a better solution to this, and that is public-private partnerships, which we are already doing at the Air Logistics Centers. By taking the creativity of the private sector with the stability of the public workforce, we actually get the best of both worlds. That would be far better than tearing this open for a food fight that would affect the quality of military equipment which is at stake. Thank you.
Lady from Hawaii.
Mr. Chairman, I yield 1 minute to Mr. Jones of North Carolina.
Gentleman from North Carolina is recognized for 1 minute.
Mr. Chairman, thank you very much. I rise in opposition to this amendment. We fought this issue of the A-76 several years ago in a bipartisan way, and we were able to put it on the shelf for a period of time. And I think trying to activate it and bring it back is absolutely the wrong thing to do. I have Cherry Point Marine Air Station in my district. I have a depot there with over 4,000 workers. They pick up and go overseas and fight these wars in Afghanistan and Iraq, leave their families back home and stand right there with the warfighter. We need to kill this amendment because it is opposed by the OMB, by the DOD, and there is no reason to reactivate the A-76. It should be dead and buried. Thank you. I yield back the balance of my time.
Gentlelady from Hawaii.
Of Utah?
Gentleman from Utah is recognized for 1 minute.
Thank you, Mr. Speaker. I had the honor of serving as a B-1 pilot in the United States Air Force for 14 years. My last assignment was working as a liaison between Air Force and a multitude of private contractors. And because of this, I saw firsthand the struggles that the military had in successfully implementing A-76 contract requirements. I saw it lead to a slowdown in work that was being performed and in some cases actual complete work stoppage. As a conservative, and I want to be clear on this, I have always supported free markets and open competition. But markets can only be free when there's a level playing field, and that is not possible under the current rules regarding A-76 contracting. Neither the military nor the private contractors are well served by a flawed process that leads to a flawed result, which is the reason why the Department of Defense has spoken out so strongly against this amendment. The Department appreciates the value of A-76 public-private competition as a tool to help the Department's workforce, and I do as well. However, the Department has also identified a number of improvements and policy changes that could lead to implementation before the moratorium is removed. The Department is working hard to put these processes in place. Let's give them a little more time to do that. And I yield back my time.
Gentlelady from Hawaii has 30 seconds remaining.
Thank you, Mr. Chairman, and I will claim the 30 seconds. Mr. Speaker, it is faulty to assume when the Department of Defense has not resolved long-standing problems in the 86 process that have been identified, the DAO and the DOD, that this is the way to proceed. We must keep that moratorium on until we are certain that, in fact, this is in the best interest of the people of our great nation. And I yield back the balance of my time.
Gentlelady yields back the balance of her time. The question is on the amendment. All those in favor say aye. All those opposed, no. Opinion of the Chair, the noes have it.
Mr.
The noes have it, and the amendment is not agreed to.
No, you don't want it. Okay.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Virginia will be postponed. It is now in order to consider Amendment Number 10, printed in Part B of House Report 113-108. For what purpose does the gentleman from Massachusetts seek recognition?
I want to claim time in support of my amendment.
Clerk will designate the amendment.
Amendment Number 10, printed in Part B of House Report Number 113-108, offered by Mr. McGovern of Massachusetts.
Pursuant to House Resolution 260, the gentleman from Massachusetts, Mr. McGovern, and a member opposed, each will control 5 minutes. The Chair recognizes the gentleman from Massachusetts.
Mr. Chairman, I want to yield myself 1 minute. Mr. Chairman, the war in Afghanistan has gone on for more than 12 years, the longest war in American history. 2,235 U.S. military personnel have been killed, over 17,000 have been wounded, and more will fall before our troops finally come home. The human and financial costs are staggering, $778 billion on Operation Enduring Freedom, nearly all of that in Afghanistan, $7.2 billion each and every month. The President has announced and is implementing a timetable to wind down U.S. military operations in Afghanistan. He's carrying it out. This amendment requires the President to stick to his timetable, accelerate it if he can, and depending on your point of view, this amendment puts the wind at the President's back or holds his feet to the fire to fulfill the promises he made to our brave troops, their families, and the American people. More importantly, it expresses that should U.S. troops be asked to remain in Afghanistan beyond 2014, then Congress needs to take its constitutional responsibilities seriously and hold a specific vote to authorize that mission and troop presence. The future and fate of tens of thousands of uniformed men and women deserve a vote. I ask all my colleagues on both sides of the aisle to vote yes on the McGovern, Jones, Smith, Lee, Garamendi amendment, and I reserve my time.
Gentleman from California.
Mr. Chairman, I rise to claim the time in opposition.
Gentleman's recognized for 5 minutes.
although I will not oppose the amendment in its current form.
Without objection.
This amendment is I yield myself such time as I may consume.
Gentleman is recognized.
This amendment is a reflection of the President's current policy in Afghanistan. My concern about the President's Afghanistan policy are well documented. I do not believe we should have given our enemies the comfort of a date certain for our withdrawal. I believe the Commander-in-Chief should only commit our troops to combat if he is committed to getting their job done right. Notwithstanding my underlying concerns, I must acknowledge the amendment articulates a policy that reflects the President's current policy. I look forward to working with the sponsors of this amendment to further perfect the language going forward. In particular, I note that the amendment expresses the sense of Congress that a post-2014 troop presence should be authorized by a vote in Congress. This Congressman does not agree with that assertion. The Congress does not vote on status of forces agreements with other countries. They're not defense treaties. It would be bad policy and a bad precedent to treat Afghanistan any differently. Moreover, the underlying bill takes meaningful steps to ensure any bilateral security agreement with Afghanistan protects U.S. interests and our troops' abilities to defend themselves. This is not a trivial issue. Our vital national security interests are at stake during this delicate time period in Afghanistan. My position is unchanged. The transition of the mission should be based upon the conditions on the ground and the input of our commanders. I, for one, hope that the President's decision-making process is not based on a non-binding restatement of his current policies. Rather, I hope his decision-making is commensurate with the national security interests at stake. I look forward to working with the gentleman further and reserve the balance of my time.
There's the balance of his time. Gentleman from Massachusetts.
Mr. Chairman, at this time it's my pleasure to yield 1.5 minutes to the gentleman from North Carolina, Mr. Jones, a co-sponsor of this
Gentleman from North Carolina is recognized for 1.5 minutes.
Mr. Chairman, thank you. It's been said before, we have been in Afghanistan for 12 years. We in Congress should have the opportunity to vote yes or no on any commitment of troops after 2014. As a former Commandant of the United States Marine Corps who agrees with my opinion that we should withdraw our troops from Afghanistan said to me, and I quote the Commandant, "What do we say to the mother and father, to the wife of the last Marine or soldier killed to support a corrupt government and a corrupt leader in a war that cannot be won?" Mr. Speaker, Congress has neglected this war for far too long. We should not allow another American to die in Afghanistan unless we vote on the policy. The American people want our troops out. The American people know that Afghan is a failed policy. The American people do not want any more blood or any more treasure to be spent in Afghanistan. I join my friend from Massachusetts and my other friends. Please vote for this amendment offered by Mr. McGovern, myself, and others. It is the right thing to do for our military. It's the right thing to do for our nation. It is our constitutional responsibility, and I yield back the balance of my time.
Gentleman from California.
Continue to reserve.
Gentleman reserved. Gentleman from Massachusetts.
Mr. Chairman, I'm privileged to now yield 1.5 minutes to the ranking member of the Armed Services Committee, Mr. Smith.
Gentleman is recognized for how long?
1.5 minutes.
Thank you, Mr. Chairman, and I thank the gentleman from Massachusetts for his leadership on this issue. My opinion is that we have done what we can do in Afghanistan. A substantial portion of the mission, which was very clear, to try to contain the Taliban and contain al-Qaeda so they could never again use it as a base to attack our country. And it is not easy work. As Mr. Jones pointed out and others, there are many, many problems and challenges in Afghanistan, not the least of which is with the corruption within the government. But our goal has always been clear. Whatever the minimum is to get a government that can stand and deny a safe haven to those who threaten America, that was a fight worth doing. But we have done what we can do. We have trained hundreds of thousands of Afghan national security forces, and it is time to turn that responsibility over to Afghanistan. It will always be a challenging part of the world in both Afghanistan and Pakistan. Violent extremists are, abundant in both places, and we'll have to keep an eye on it. But we do not need to have the troop levels that we have now. We need to draw down in a very responsible way, and I think the gentleman's amendment lays out a plan to do that. And therefore, I support it, and again, I support him for his efforts to get us out of Afghanistan as soon as we responsibly can. I yield back.
Gentleman from California. Gentleman reserved. Gentleman from Massachusetts.
Mr. Chairman, how much time do I have left?
1 3/4 minutes remaining.
Can I yield? Can I yield? No. Can I yield 30 seconds to the gentleman from California, Mr. Rohrabacher?
Gentleman from California is recognized for 30 seconds.
Keeping our troops in Afghanistan any longer than they have to be, absolutely be there, is a disservice to those people who are protecting our country. They are now doing what we said they would do once we've announced that we're leaving. They're picking our people off. How do we explain to those parents who are losing their children in the next few months? Let's not send any more over there. And if we do, let's make sure that it's a decision made by the House of the people rather than just by a clique someplace in the Pentagon or elsewhere. We need to make sure that we're watching out for our troops, and I think that this is the best amendment that would do just that. Thank you.
Gentleman from California? Gentleman reserved. Gentleman from Massachusetts?
Mr. Chairman, I will close if the I'm going to, for our sake, I yield myself the remaining time.
Gentleman's recognized.
Mr. Chairman, hundreds of billions of dollars, tens of thousands of U.S., NATO, allies, and Afghan lives lost. It is time to end the war in Afghanistan, bring our troops home, and take seriously our duty as a Congress to specifically authorize any mission and troop presence beyond 2014. We are not bystanders in this war. We are responsible for sending thousands and thousands of men and women over into Afghanistan. The least we can do is take seriously our duty as a Congress and authorize any mission and troop presence beyond 2014. Members of Congress ought to go on record as to where they stand on this. We owe it to our troops. We owe it to their families and the American people. And I would urge my colleagues to support the McGovern-Jones-Smith Amendment on Afghanistan and send a signal to the administration and to others that we take our responsibility in this matter very seriously. We will have a vote if this war goes beyond what the President has stated. And with that, Mr. Chairman, I yield back the balance of my time.
Gentleman from California.
Mr. Chairman, at this time I yield the balance of my time to the gentleman from Texas, the Vice Chairman of the committee, Mr. Thornberry.
Gentleman from Texas is recognized for 3 minutes.
I thank the chairman for yielding. And Mr. Chairman, I would simply want to point out members have a variety of opinions about Afghanistan, and a number of members have come to the floor to voice their opinion that we ought to leave Afghanistan. I understand that. That's not what this amendment says. This amendment basically restates the President's policy with regard to Afghanistan, and then, as the gentleman from Massachusetts said, it says Congress ought to exercise its responsibilities under the Constitution. Now, we can do that in a variety of ways. We can have oversight hearings. We can have amendments dealing with funding, and we've had those sorts of things before. But the point is that some of the rhetoric doesn't match the amendment. As the chairman pointed out, the underlying bill tries to encourage a bilateral security agreement, so that looking ahead beyond 2014, it is very important to many of us that any American troops who are remaining in Afghanistan have the protections that they should have under such an agreement. And so the underlying bill has a fence on some of the funding going to Afghanistan until there is that sort of bilateral security agreement. So the point is, moving ahead beyond 2014, there are lots of unknowns at this stage. We're trying to help shape it in a way that is beneficial for our security but also protects our troops. But the underlying amendment, to get back to what's before us, basically restates the President's position, says Congress ought to exercise its responsibilities. I think that's true. Meanwhile, members can have their own opinions about Afghanistan and what should happen between now and then. I yield back.
Gentleman yields back. The question is on the amendment offered by the gentleman from Massachusetts. All those in favor say aye. All those opposed, no. In the opinion of the chair, the ayes have it.
Chairman, I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Massachusetts will be postponed. It is now in order to consider Amendment Number 11, printed in Part B of House Report 113-108. For what purpose does the gentleman from Virginia seek recognition?
Mr. Chairman, I move to consider Amendment Number 11.
Clerk will designate the amendment.
Amendment number 11, printed in Part B of House Report number 113-108, offered by Mr. Goodlatte of Virginia.
Pursuant to House Resolution 260, the gentleman from Virginia, Mr. Goodlatte, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Virginia.
Thank you, Mr. Chairman. I yield myself such time as I may consume. On September 18, 2001, Congress enacted the authorization for the use of military force, which empowered the President to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks in order to prevent any future acts of international terrorism against the United States. Section 1021 of the fiscal year 2012 National Defense Authorization Act reaffirms the President's authority to detain so-called enemy combatants by affirming that the authority of the President to use all necessary and appropriate force pursuant to the authorization for use of military force includes the authority for the Armed Forces of the United States to detain covered persons pending disposition under the law of war. A number of members from both sides of the aisle have expressed extreme discomfort and even outrage at the notion that a United States citizen apprehended on United States soil can potentially be held indefinitely under this act. To that end, I supported an amendment to the fiscal year 2013 National Defense Authorization Act that reaffirmed the ability of the writ of habeas corpus for availability of the writ of habeas corpus for any person detained in the United States pursuant to the 2001 AUMF or the fiscal year 2012 NDAA. While this provision was a step in the right direction, many would view the current habeas proceedings as unfair to the petitioner. For instance, the government enjoys a rebuttable presumption that its evidence is accurate and authentic, and it must only prove its case by a preponderance of the evidence. To most Americans, this would not seem to be a fair fight. For United States citizens, the burden should be on the government to prove that the detainee is an enemy belligerent. U.S. citizens should not be put in a position to prove that they are not a terrorist. Today, with this amendment, I want to make clear that nothing in the AUMF or the fiscal year 2012 NDAA or any other law for that matter can be construed to deny the great writ of habeas corpus. Further, this amendment requires that in habeas proceedings for United States citizens apprehended in the United States pursuant to the AUMF, the government must prove by clear and convincing evidence that the citizen is an unprivileged enemy combatant and there is no presumption that the government's evidence is accurate and authentic. This is an important amendment that should alleviate any of the well-founded concerns of the American people concerning the possibility of indefinite detention of United States citizens. The presumption of innocence until proven guilty will be preserved by adopting this amendment. I want to thank the Chairman of the Armed Services Committee for supporting this amendment, and I appreciate his commitment to ensuring that this language stays in the bill as it moves through the legislative process, and I urge my colleagues to support this amendment, and I reserve the balance of my time.
The gentleman reserves the balance of his time. Gentleman from Washington.
I rise to claim the time in opposition.
The gentleman is recognized for 5 minutes.
I yield myself 2 minutes.
The gentleman is recognized.
Thank you, Mr. Chairman. Make no mistake about it. Even with this amendment, the President of the United States, the Department of Justice, will still have the ability to indefinitely detain people captured in the U.S., be they U.S. citizens or not, without the normal due process of law. Habeas will be available, but even with this increased standard, it is a very minimum standard, and it does not afford the normal Article III court rights that are in the Constitution for everybody else. The President will still have the ability to indefinitely detain people here in the U.S. This amendment is insufficient, first of all, to deal with the concerns that I think people legitimately have about excessive executive power over people in the U.S. The executive will continue to maintain, under the authorization for the use of military force, the ability to indefinitely detain anyone who is deemed to be a covered person, an enemy combatant, And yes, it is a slightly higher standard, but it is not the beyond a reasonable standard that is normally required to incarcerate somebody. The President doesn't need this power. President Obama has never exercised it. President Bush only briefly exercised it in 3 instances. He doesn't need the power, but to keep it on the books is a threat to liberty and a threat to freedom here in the U.S. And the specific problem with this amendment is it carves out U.S. citizens, whereas the constitutional protections, and deliberately, were for any person. If you read the Constitution, the Bill of Rights, it doesn't say any U.S. citizen, it says any person. Now, on habeas, you will have 2 different standards. You will have the standard to hold a non-citizen, which will be, I gather, still the preponderance of evidence. The government will still have the presumption that what they're saying is true, but for a U.S. citizen you will have a different standard. That really messes with the Constitution. There's a very simple way to do this. I'll have an amendment and a couple of amendments that gets rid of the ability to indefinitely detain anyone captured in the U.S. Straightforward, no question, no weasel words, no back and forth between U.S. citizens and not. It gets rid of indefinite detention. I would urge support for that amendment and opposition to this one, and I reserve the balance of my time.
Gentleman from Virginia.
Mr. Speaker, I yield myself 1 minute.
Gentleman next.
I want to respond to the gentleman. First of all, the contention that there is no distinction drawn between United States citizens and non-citizens in the context of the Fourth Amendment of the United States Constitution. The Supreme Court has held that the Fourth Amendment does not operate to protect all citizens, regardless of their connections to American society. So the 9/11 hijackers are not in the same status